Hello, my name is James Carroll, a partner in the Family Law Department of Russell Cook Solicitors in London. Russell Cook is a law firm of over 150 solicitors who include civil and family mediators, arbitrators, collaborative family lawyers and judges. Together we advise on all areas of the law, though my specialism is family law. My practice encompasses the legal and financial ramifications of relationship breakdown and relationship formation. This includes marriage and civil unions, wealth protection, family settlements and prenuptial agreements, property disputes, family businesses and family trusts. My particular specialism is in cross-border family cases. Today's webinar is intended to introduce the new EU Directive on certain aspects of mediation in civil and commercial matters. I will provide an introduction to mediation and the Mediation Directive itself, a summary of the key provisions of the Directive, identifying areas of potential controversy and difficulty, including the question of compulsory mediation, the matter of confidentiality, and the issue of the enforcement of mediated agreements. Let's start, however, looking at mediation itself. What is mediation? Mediation is a form of alternative dispute resolution. It is not the only form, but it is possibly, other than direct negotiations, perhaps the most common form. The central tenet of mediation, including mediation under the Directive, is that a neutral and independent third person assists the parties in their direct discussions. The objective of this is to enable the parties to reach an agreement or consensual solution to a dispute or legal issue. Many definitions of mediation refer to mediation as being voluntary. However, the mediation referral system envisaged by the Directive and the role of the courts under the Directive cause the voluntary nature of mediation to be a little bit more complex. I will return to this later. Mediation is a flexible concept. There is no one accepted definition of mediation or method of practicing mediation. Variants include whether or not the parties attend alone or with their legal representatives, whether or not the mediator operates alone or in conjunction with a co-mediator, perhaps from a business, technical or therapeutic background, whether mediation is integrated, runs parallel, or is fully separated from the court process. Recital 6 of the Directive sets out the benefits of mediation, namely it can be more cost effective, it can be quicker than conventional court proceedings, and it can be tailored to the specific needs and objectives of the parties. It can also help to preserve an amicable and sustainable relationship, which may be important in a family or business context. Finally, it is said that mediated agreements may be more likely to be complied with voluntarily as they were reached through consensus. The Directive specifically notes that the benefits of mediation are particularly obvious in cases with a cross-border element. This is perhaps because the strict legal solutions may be in conflict or are complex, and hence proceedings may be costly. I now turn to the content of the Directive itself. I will consider the background to the Directive, the scope of the Directive, and the main provisions of the Directive. The Mediation Directive is a long-awaited result of much discussion regarding the role of mediation, the role of alternative dispute resolution, and its relationship and interaction with the courts. The issue rose to prominence following the European Council decision in October 1999 to promote alternative procedures across member states. In April 2002, the European Council's Green Paper explored the existing arrangements and their range and effectiveness across member states. The Mediation Directive itself was adopted by the European Parliament on the 23rd of April 2008 and eventually came into force on the 13th of June 2008. Member States were required to bring the provisions of the Directive into force by the 21st of May 2011. It is therefore an active directive. The objectives of the Directive are set out in Article 1. These are to promote and to facilitate mediation. The methods of promoting and facilitating mediation will be considered further below. However, before we consider that point, we need to consider whether this applies to all mediations. The answer is no. The Directive only applies to cross-border mediations. Recital 8 to the Directive says that the Directive can apply to domestic mediations, but this is a matter of choice. The position in England is that currently it does not apply to domestic mediation, whereas I understand that the position in Italy is that they wish it to apply to both domestic and cross-border mediations. Further, the directive does not apply where the disposal of the claim or the legal dispute is not in the party's discretion. An example of this is family proceedings before the English court, which will require the court to exercise its discretion and approve any agreement or draft consent order submitted to it. The agreement itself is not binding upon the court and is not enforceable until such time as the court has exercised such discretion. Article 2 of the Directive defines what constitutes a cross-border mediation. This is where the parties are either habitually resident or domiciled in different member states. For companies, this applies where their statutory or registered office is across different member states, or potentially where their principal place of business takes place across different member states. The relevant date for the purposes of considering whether the parties are in different member states is set out in Article 2. This is either the date when the parties agree to use mediation, or whether they are ordered or compelled to attend mediation by the court. Turning to the content of the directive and its central terms, there are 4 areas which I would like to particularly explore. The first is a question of facilitating mediation and the relationship between mediations of the court. The second is the question of confidentiality of mediation and mediated agreements. The third is the issue of limitation, and finally that of enforceability. The first key issue is how member states are required to facilitate and encourage mediation. This issue is tied up with the debate regarding compulsory mediation, or rather, whether mediation can and should be made compulsory. Let's start, however, with the issue of facilitating mediation. Article 4 of the Directive requires member states to develop codes of conduct for mediation services and mediations themselves. It also requires the introduction of quality control mechanisms for mediation services. This is a minimum requirement, and the details of how to implement the codes of conduct and the quality control mechanisms are left for individual states to determine. Turning now to the question of encouraging mediation, the word encouraging is perhaps a misnomer. The directive is intended to work in parallel to legal proceedings and court proceedings. Accordingly, Article 5 of the directive allows courts to encourage mediation and to impose sanctions for failure to engage in mediation. This has 2 elements. Firstly, the court has an ability to refer parties to mediation information sessions, and secondly, the court can invite or rather compel the parties to attend mediation itself. I'll give 2 examples of this in an English context. The first is mediation information sessions. In family proceedings in England and Wales, the court requires parties to attend a session in which they will be given information regarding mediation services before they are permitted to issue an application. The information session itself is not mediation, it is merely the provision of information regarding what mediation is and the benefits it can offer. The second example, again from an English law perspective, is the ability of the court in civil proceedings to stay the proceedings and require the parties to attend mediation. If the parties fail to do so, they must explain to the court their reasons for this and can be sanctioned in costs. Again, this is not about compelling the parties to continue mediation or reach a mediated agreement, but rather to attempt to resolve their issues direct. The crux of the debate, therefore, is whether, under the directive, this means that there is going to be compulsory mediation. My answer to this debate is that this is a qualified no. There can be a compulsory referral to mediation information sessions. There can be a compulsory requirement for parties to attempt mediation. However, reaching a mediated agreement can never be made compulsory. It requires the cooperation of the parties. It possibly could be said, therefore, the introduction of the directive ends the debate as to whether compulsory referral to mediation constitutes a breach of a party's rights under Article 6 of the European Convention on Human Rights and Access to Justice. The second issue which I would like to consider is that of limitation. If parties are to be compelled to attend information sessions regarding mediation, or even to attempt mediation, and therefore are restricted in their ability to issue proceedings straight away, could this cause issues in terms of the expiry of limitation periods? The directive deals with this adequately by recognising the issue that this could potentially cause. It combats this issue under Article 8 of the Directive, which expressly states that parties who choose mediation can still apply to use other methods of dispute resolution, including court proceedings, if mediation fails. This is despite the passing of the limitation date. The third issue which I wish to explore is that of confidentiality of mediation. This is a hot topic of debate, both in relation to the negotiations that take place in mediation itself and the ability of mediators to be compelled to give evidence in subsequent proceedings. It is often presumed that all negotiations in mediation are confidential. Article 7 of the Directive addresses this. It is not as clear-cut a position to say that mediation is always confidential. There are two areas of potentially less controversy regarding where mediation information may be released. The first is the usual public policy exceptions, which override confidentiality. The second is possibly where information derived from mediation is required in relation to the enforcement of an agreement reached at mediation. The third area is potentially more controversial. This concerns the question of overriding confidentiality where the parties agree. There is a concern that mediators may be called to give evidence in proceedings if the parties both consent. This undermines, in some people's arguments, the question as to a mediator's impartiality, neutrality, and obviously the issue of confidentiality. The final key issue concerns the enforcement of mediated agreements. This is addressed in Article 6 of the Directive. The objective is to ensure that mediation and mediated agreements have teeth. Accordingly, written mediated agreements are to be capable of enforcement. The exceptions of this are largely limited to where the agreement is contrary to national law. Further, the Directive provides that agreements reached in mediation in one member state should be enforceable in another member state, provided again that agreement does not contradict national law. To conclude, in summary, the practice of mediation, and indeed of ADR generally, is well established across member states. The benefits of mediation are clear, but for the avoidance of doubt, the Directive spells these out. Interestingly, the Directive itself is relatively short. Sometimes it reads as if it is a statement of principles or objectives. However, it contains far-reaching and perhaps controversial provisions regarding both the practice and the development of mediation. It is clear that the Directive is designed to encourage mediation, but more so than this, the Directive gives methods of encouraging mediation legitimacy and teeth. In particular, it gives the courts powers to potentially compel mediation, although I reiterate, not the ability to force mediated agreements. If, however, the parties do reach an agreement at mediation, then the Directive again gives those agreements teeth. I wish to reiterate that this only applies currently to cross-border mediations. However, the Directive may lead the way for future mediation developments in the domestic arena. Looking at the question of next steps, Article 11 of the Directive provides for a review. It is anticipated that this will take place in May 2016. In the interim, we await to see how the Directive influences the developments of cross-border mediations, but also how it influences domestic mediations, the debate regarding enforceability, confidentiality and the compulsory nature of mediation, and the developments of mediation practice generally. Thank you.